Today we heard that the Clintons set deposition dates to testify before the House Oversight Committee. Any reaction to that and related to these questions? I think it's a shame, to be honest. I've always liked her. She's a very capable woman. She was better at debating than some of the other people, I will tell you that. She was smarter, smart woman. I hate to see it. But then I look at my own situation. They went after me like they wanted me to go to jail for the rest of my life. Then it turned out I was innocent, very innocent. I had a very smart friend, a very wealthy man, knows life, streetwise guy. He said you have to be the most honest person anywhere in the world, because there's never been anybody who's been examined up and down like I have.
President Trump is on his way back to the US after that two-day state visit to China and those talks with President Xi. He was seen off by government officials and school children waving flags. The two sides have given differing accounts of what was discussed during lengthy
a fight for independence, because that would be a very strong confrontation. And I heard him out.
Would the US defend Taiwan if it came to it?
I don't want to say it. I'm not going to say that.
Picture this. It is 1 a.m. The President of the United States, the most powerful elected official on the planet, is awake, and he is not reviewing intelligence briefings. He is not on a call with a foreign leader managing some late-breaking international crisis. He is on Truth Social, posting, raging, attacking the Supreme Court of the United States in real time. The same court that he appointed 3 justices to. The same court that has been one of the most consequential institutional forces in his political career, going after it at 1 a.m. because of how oral arguments went earlier that day. And this is happening right before he is scheduled to appear before that very court. Come on, are you kidding me? This is wild. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video.
Yeah, I mean, my assessment is that there was actually very little coming out of this summit, right? And my bumper sticker for this summit is that there was no escalation, which would have been bad, but there were also no concessions, I think, really from either side. There were some modest concessions on the Chinese side, primarily on the trade front, it looks like. Those haven't necessarily been confirmed from the Chinese. But I think what we've got is, people have been describing this as stability.
introducing you. What did you make of the expertise, the China expertise, among the delegation the US sent?
It was lacking, in all honesty. I mean, it was very striking looking at the composition of the delegation. It was really business leaders, a gaggle of senior U.S. officials who have been deeply involved in dealing with the Chinese throughout this administration, but not a lot of China expertise.
And finally, do you think that Donald Trump should be deposed by this committee? Absolutely. I was a lawyer, and as a lawyer, you would look for pattern and practice if you were deposing a witness in a case that you were trying. If you were in court, what did you know about this person? What you knew could influence how you questioned that person, how you tried the case. Donald Trump has been held civilly liable for sexual assault by a jury of his peers. 9 members of a jury found him liable in the sexual assault of E. Jean Carroll. That is what happened in early April of 2026. And before I get into the details, because the details here matter a lot, I want to step back for a second and ask you to consider what this situation actually looks like from the outside. Not from the perspective of a Trump supporter, not from the perspective of someone who despises him, but just from the perspective of anyone who understands how high-stakes legal and institutional proceedings work. When you are a party to a case before the Supreme Court of the United States, when the justices are actively deliberating on questions that directly affect your administration's policies, potentially your own legal exposure, the conventional wisdom from every legal advisor, every communications professional, and every strategist who has ever operated at that level is the same. You stay calm. You stay disciplined. You let your lawyers do the talking. You do not give the opposition any additional ammunition. You absolutely do not post angry screeds at 1 a.m., attacking the institution that is deciding your fate. That is not a complicated piece of advice, and it was apparently not followed. Here is what the reporting tells us about what went down. On April 1st of 2026, oral arguments were heard at the Supreme Court on the Birthright Citizenship case, a case that goes to the heart of one of the most consequential immigration policy positions the Trump administration has taken: birthright citizenship. The principle that anyone born on American soil is automatically an American citizen is enshrined in the 14th Amendment and has been settled constitutional interpretation for well over a century. The Trump administration has been challenging that interpretation, seeking to end birthright citizenship for children born in the United States to parents who are not legal residents. It is one of the most aggressive and legally contested positions in the administration's immigration agenda. In the oral arguments on April 1st, things did not go well for the administration. Multiple administration arguments were reportedly rejected or received skeptically by justices during the hearing. And Trump, who was reportedly present in the courtroom for at least part of those arguments, which is itself unusual, presidents do not typically sit in on Supreme Court oral arguments, reportedly stormed out after the session. Reporters who were present described his demeanor as agitated. Some accounts used the word expletive-filled to characterize how he was talking in the immediate aftermath. Come on. And then came the early morning Truth Social thread. The Daily Beast reported that in the hours following the hearing, stretching into the early morning hours of April 5th, Trump raged at the court in a way that was captured in his posts and described by people familiar with his state of mind at the time. The posts were angry. They were pointed. They attacked the court, his court, the court shaped in significant part by his own appointments, for how it handled the proceedings. And they were posted at 1 a.m, which tells you something about the emotional state that produced them, regardless of your political perspective. Because 1 a.m. posts are not strategic communications. They are not carefully worded statements reviewed by a legal team and signed off by a communications director. They are the output of a person who is upset, who is awake when he should probably be asleep, and who has an unmediated, direct channel to millions of followers that he is not being careful with in that moment. Are you kidding me? That is not a presidential posture heading into a major Supreme Court situation. Now, I want to be clear about something before we go any further. The substance of the birthright citizenship case, the legal and constitutional questions it raises, is genuinely complicated and genuinely important. There are serious legal scholars who have argued that the current interpretation of the 14th Amendment needs to be revisited. There are equally serious legal scholars who argue the current interpretation is settled and correct. That is a legitimate constitutional debate that the Supreme Court is supposed to resolve through its deliberative process. That is not the story here. The story here is not about who is right on the legal merits. The story is about the President of the United States having a very public, very visible, very emotionally uncontrolled reaction to a legal proceeding that directly affects his administration and his policies, and doing so in a way that went viral, that gave his opponents exactly the kind of footage and screenshots they need for political ads, and that raises real questions about how a man in his position manages himself under legal pressure. That is the story, and it is one that has a context, a pattern of prior similar behavior that makes it more significant, not less. Stay with me, because here's the thing that the most astute political observers are noting about this episode. This is not the first time, not even close. Business Insider and Politico have both compiled reporting on a documented pattern of Trump erupting in court and hearing settings, going back through multiple legal proceedings. The New York civil fraud trial, other proceedings, multiple examples of agitation, raised voices, and behavior that reporters present in those settings described as inconsistent with a composed, disciplined demeanor that typically characterizes how powerful people manage themselves in high-stakes legal environments. And every time one of those episodes happens and goes viral, every time there is footage or reporting that reads as emotional dysregulation under legal pressure, it gets filed away by journalists, by political operatives, by campaign ad producers, by voters who are forming impressions about fitness and temperament. This April 2026 episode is the latest entry in that file, and it is going to be one of the most widely seen because of the timing, the subject matter, and the sheer level of social media amplification it generated in the 48 hours after it happened. All right, so let me walk you through why this story is so much bigger than just a presidential rant on social media in the middle of the night. Because if you look at it that way, you might be tempted to file it under the category of things that happen, everyone gets upset for a moment, and then it fades away and is forgotten. That is not what is happening here. What is happening here involves legal stakes, political stakes, institutional stakes, and a pattern of behavior that collectively tell a story much more significant than any single incident could tell on its own. And the people who are paying the most attention to this, the legal analysts, the campaign strategists, the political scientists who study presidential behavior under institutional pressure, they are not dismissing this episode. They are watching it very carefully because it connects to a set of larger questions about how this presidency is functioning and how it is going to manage some of the most consequential legal and constitutional challenges it faces. Come on, this is serious. Let me show you why. Start with the legal stakes of the birthright citizenship case specifically, because you need to understand what is actually being decided here to understand why the reaction to the oral arguments was so heated. The 14th Amendment to the Constitution says that all persons born or naturalized in the United States and subject to its jurisdiction are citizens of the United States. That language has been interpreted consistently since the 19th century to mean that being born on American soil makes you an American citizen, period, regardless of the immigration status of your parents. This is what lawyers call birthright citizenship, and what the Latin phrase jus soli means, citizenship of the soil. The Trump administration has been arguing that this interpretation is wrong and has taken executive action to try to end birthright citizenship for children born to parents who are not legal residents. That executive action was immediately challenged in federal courts. Multiple lower courts blocked it, and the case worked its way up to the Supreme Court, where it landed in oral arguments on April 1st. The stakes could not be higher. If the Supreme Court upholds the administration's position, it would represent one of the most significant changes to constitutional interpretation in American history, affecting potentially hundreds of thousands of people born in the United States every year and reshaping the legal basis of American citizenship that has been in place for over 150 years. If the court strikes down the administration's position, which the reception at oral argument suggested was a meaningful possibility, it would be a significant legal defeat on one of the administration's signature immigration policy priorities. The president sitting in on arguments and then storming out after they went badly is a very visible signal of how high the stakes feel from inside the White House. And visibility matters in legal proceedings even when it should not, because the people watching form impressions. Are you kidding me? You have to be aware of how this looks. Now, let's talk about the 1 in the morning Truth Social posts and why they matter beyond just the obvious optics problem. In any legal proceeding, and especially in a proceeding before the Supreme Court of the United States, which is the final word on constitutional law in this country, the behavior of the parties and their representatives is watched and evaluated, not just by the public, but by the institutional actors involved in the process. Justices are human beings. Clerks are human beings. The entire apparatus of the court is populated by people who read the news, who are aware of public statements, and who are, even if they would never formally acknowledge it, forming perceptions of the parties before them based on everything they observe. When the President of the United States goes on social media at 1 in the morning and attacks the court that is deciding his case in angry and intemperate language, that does not happen in a vacuum. It is visible to everyone, including the people making the decision. Now, justices are not going to change their constitutional analysis because a president posted something angry on Truth Social. That is not how the Supreme Court works, and it would be wrong to suggest otherwise. But the optics of the behavior, the image it creates, the impression it leaves, do not help. They reinforce a narrative about the administration's relationship to institutional norms and judicial authority that critics have been building for years. And that narrative has political consequences, even if it has limited direct legal ones. Come on, you do not have to agree with the critics to understand that the behavior is handing them material they are going to use effectively. The pattern question is where this story gets most consequential and most revealing about the longer arc of this presidency. Because individual incidents can be explained away. A bad day, an unusually stressful moment, an out-of-character reaction to exceptional circumstances. All of those explanations work for a single, isolated incident. But when there is a documented pattern, when Business Insider and Politico have both done the work of compiling examples across multiple legal proceedings and multiple settings of behavior that follows the same emotional arc, the single incident explanations stop working. Patterns require a different kind of explanation. They require you to look at what the consistent underlying dynamic is that produces the same kind of reaction in similar circumstances. And what the pattern of Trump's behavior in legal settings tells you, across the New York civil fraud trial, across earlier court and hearing settings, and now in the Supreme Court Birthright Citizenship episode, is that legal pressure produces a specific and consistent response. That response involves visible agitation, public statements that most lawyers would advise against, and behavior that gives political opponents material they can use effectively in the broader public arena. That is not a political attack on Trump. That is a factual description of a documented behavioral pattern that has been reported by multiple outlets with sourced accounts from people who were present. And that pattern matters enormously as this administration faces an ongoing series of significant legal challenges over the next several years. Are you kidding me? The pattern is the story. Let's talk about the political ad dimension of this, because this is where the immediate practical consequences for the administration and for Republican candidates heading into the midterms are most direct and most measurable. Campaigns spend enormous amounts of money and effort trying to produce footage that tells a story about an opponent's character, temperament, and fitness for office. The most effective political ads are not the ones that make abstract arguments about policy. They are the ones that show you something, a facial expression, a statement, a moment of behavior that speaks to who a person really is under pressure. And what April 2026 handed to Democratic campaign operations and to the broader opposition media ecosystem is a set of very specific, very shareable, very emotionally legible images and clips. A president storming out of the Supreme Court after arguments went badly. A 1 a.m. Truth Social rant. Reporters describing his demeanor as agitated and expletive-filled. These are not abstract policy disagreements. These are visceral images and moments that communicate something directly about how this president manages himself under legal and institutional pressure. And the political ad producers who are right now sitting in campaign offices and opposition research shops, they are not missing this. They are clipping it. They are contextualizing it. They are preparing to use it in paid advertising, in earned media, in social media content designed to reach the specific voters who are most persuadable on the question of presidential temperament and fitness. Come on. This is exactly the kind of material that shifts opinion at the margins, and margins are what elections are decided by. All right, let's land this clearly. Here is what is actually going on at every level of this story. The legal level, the political level, and the deeper question about what all of it means for how this presidency is functioning and how it is being perceived by the people who will ultimately decide its political legacy. At the legal level, the most immediate and most concrete level, the Supreme Court Birthright Citizenship case is one of the most significant constitutional questions this administration has put before the judiciary. The stakes are enormous. A win for the administration would represent one of the most consequential changes to constitutional interpretation in modern American history. A loss, which the oral argument reception suggested was at least a meaningful possibility, would be a significant legal defeat on a signature immigration policy priority. And the way the administration has managed its public posture around this proceeding, the presence in the courtroom, the storming out, the 1 a.m. post attacking the court, has not made the legal situation easier. It has complicated it. Not because justices are going to change their constitutional analysis based on a Truth Social post. They are not. But because the behavior reinforces a narrative about the administration's relationship to judicial authority and institutional norms that affects how the case is covered, how the public processes whatever decision comes down, and how Congress and other institutional actors respond to the outcome. Legal proceedings do not happen in a media vacuum. They happen in a political and media environment that shapes how their outcomes land. And the administration has not managed that environment well in the days surrounding this proceeding. Come on, that is the straightforward assessment. At the political level, the level that matters most for what happens between now and November, the episode has handed the opposition a very specific and very usable gift. The clips, the screenshots, the reported accounts of agitated and expletive-filled demeanor, the 1 a.m. post, all of it is now in the public record and in the content libraries of every campaign and opposition research operation that has any interest in using presidential temperament as a political issue. And temperament is not a trivial issue for voters. In poll after poll across multiple election cycles, voters consistently cite character, stability, and temperament as among the most important factors in how they evaluate presidential candidates and sitting presidents. The voters who are most movable on those dimensions, the suburban moderates, the soft Republicans, the true independents who decide competitive races, are precisely the voters who are most sensitive to footage and reporting that suggests the president is not managing himself with the composure and discipline the office demands. The opposition did not have to manufacture this. They did not have to stretch the truth or use misleading editing. The behavior happened. The reporting is on the record, and the clips are going to circulate in political advertising for months. Are you kidding me? This is exactly the kind of unforced error that changes the shape of a political environment. The fitness and stability narrative is the one that this administration has always been most vulnerable to and least effective at managing. And the April 2026 episode is going to become a major new data point in that ongoing narrative battle. Because here's the thing about narratives in politics. They are built incrementally. One episode by itself rarely defines a narrative, but when a new episode fits cleanly into an established pattern, when critics and analysts can say this is consistent with a documented history of similar behavior in similar high-pressure settings, the new episode does not just stand alone. It reinforces and amplifies everything that came before it. Every previous courtroom eruption, every previous instance of public agitation under legal pressure, every previous late-night social media post that was later explained away as frustration. The April 2026 Supreme Court episode connects to all of those prior moments in the minds of voters who are paying attention. And it makes the overall picture of presidential temperament under pressure more vivid and more concerning for the voters who are most persuadable on that question. The administration's allies will push back on this framing. They will call it media bias and political weaponization of normal human frustration. And some of that pushback will land with the base. But the base is not the audience that matters most in a midterm year. The persuadable voters in the middle are the audience that matters. And with them, this episode is going to do damage. Come on, here's what to watch for going forward. The specific signals that will tell you how significant this episode ultimately becomes in the larger political picture. Watch for whether the Supreme Court Birthright Citizenship decision lands before November, because if it does, the outcome is going to be framed entirely through the lens of what happened in and around the April oral arguments. A loss for the administration will be reported in the context of the storming out and the 1 a.m. post, reinforcing the narrative of an administration that lost its composure when the stakes were highest. A win will be used by the administration to argue that the meltdown narrative was overblown and that the legal strategy ultimately succeeded regardless of the surrounding drama. Watch for whether clips from the April episode appear in Democratic campaign advertising, because the timing and targeting of that ad spending will tell you how much weight the opposition is putting on the temperament issue as a persuasion tool versus a base mobilization tool. Watch for any additional incidents in legal or institutional settings, because a third or fourth entry in the pattern makes the pattern undeniable and unspinnable in ways that even 2 or 3 incidents leave some room to argue around. The pattern is the vulnerability. More entries in the pattern close off the escape routes. Here is the absolute bottom line. The President of the United States attended a Supreme Court oral argument on one of the most consequential constitutional questions before the court in decades. The arguments did not go the way the administration wanted. In the President's response, storming out, posting angrily on social media at 1 in the morning, displaying the kind of visible agitation that reporters in the room felt compelled to document and describe in detail, was not the response of a man who was managing himself and his institution with the composure and discipline that the moment required. It gave his opponents exactly what they needed. It fit cleanly into a documented pattern of similar behavior under legal pressure. It circulated virally and generated enormous social media engagement that extended its reach far beyond what would have happened with a more measured response. And it happened at a moment heading into a midterm year with Republican prospects already under pressure, when the administration could least afford another viral episode feeding the temperament and fitness narrative. Come on, the legal calendar is not done. There are more proceedings ahead, more moments where composure and discipline are going to be essential. And the question now, the question that everyone watching this is asking, is whether the behavior in April was an outlier or whether it was a preview of what comes next. Because if it is a preview, the next chapter of this story is going to be even harder to manage than this one. Do not go anywhere. It is coming.